Okay, so good afternoon, everyone. Welcome to the second session of LawKNIT uh, contracting do's and don'ts. My name is Amol Apte, and I'll take you through today's session where along with do's and don'ts of the contracts, we'll also learn about certain important clauses. What do we mean by boilerplate clauses? Uh, what are the certain important things that we need to keep in mind while contracts are drafted? And let's hope we can close all these in half an hour session. After that, we'll have 10 minutes of question and answer, where I'll be happy to answer any of the queries that you may have. Uh, so let's just straight away get into it. So let's just first start with what is this LawKNIT learnings that we are talking about. LawKNIT learnings is a quarterly session that we usually do for our clients. Uh, the focus is on non-legal guys. So typically people who attend these training programs are from sales, finance, even members of legal team, HR teams, to enable them understand the practical aspects on commercial contracts and make them understand as to how to look at the contracts from the point of view of their businesses. Okay. Now, the roadmap that we'll follow today uh, is going to be, we'll talk a little bit about types of contracts. Uh, uh, this is going to be a suggestive list of types of contracts. Well, there can be a very, very long list of contracts, but this is a suggestive list of contracts that you'll come across on your in your daily transactions, daily work. We'll talk a little bit about the transaction documents. Uh, when you do fundraise and all that, what are the kind of documents that you come across. We'll talk about certain critical clauses, as I said before, certain important clauses that you need to keep in mind in every contract. We'll talk about boilerplate clauses, understand what boilerplate clauses mean and what are those clauses that fall under this category, and then go up to do's and don'ts of contracting. That's how we'll take today's journey. Quickly moving forward, as I said, the first thing that I wanted to take you through is types of contracts. Again, it is a suggestive list and not an exhaustive list, but these are the ones which you will come across on a almost on a daily basis. And it's always good to have a basic understanding of what these documents actually mean. The first one that we have listed down here is LOI, which is letter of intent or a term sheet. What does this document actually mean? It's a non-binding, the word itself suggests, right? It's LOI, which is letter of intent. So you're just expressing the intent to get into a commercial contract. So it typically is non-binding in nature. However, when it takes form of a term sheet, when you are doing a transaction, it may have certain clauses which the parties may want to be binding on each other, just like exclusivity or general terms. The second one is memorandum of understanding, slightly similar to letter of intent. However, it just captures the understanding that the parties have entered into. It could be binding in nature. It may not be binding in nature. It could be just a umbrella document which defines the intent of the parties on how the commercial arrangement is going to be governed, and a lighter structure, not very uh, technical in nature. If the parties want that, then the memorandum of understanding is signed. The third type of document which you may come across on a daily basis, on a regular basis, just before you enter into any commercial arrangement, is NDA or non-disclosure agreement. What does this mean? This document is meant to protect the parties into the contract from any breach of confidentiality. So essentially, these documents cover the information that is termed as confidential and the obligations of each of the parties towards that confidential information. What do I need to do to keep it confidential? And if I fail to do so, what are the obligations that I'll be liable for? That's your non-disclosure agreement. The third type of agreement which you commonly come across is either the service agreements or sale agreements, which are typically identifying the scopes of service or the products that you are going to sell, deliver to the parties, the warranties around it, the timelines, the payment structures, etc., etc. Those are the most common contracts that you will come across, which are service and sales agreements. Lease or leave and license agreements uh, that you come across on a daily basis when you deal with residential or commercial properties or godowns or any immovable property. Those are lease agreements. Typically, any rent agreement or an agreement where you actually get a license to use a particular immovable property is governed by these kind of agreements. While there are differences between lease and leave-in license agreements, but that we'll reserve for some time, some later time. But typically, they govern the parties' rights and obligations around an agreement where one party is transferring the rights to use his or her property to the other party. Then SLAs, you may have heard the name SLAs quite a few times, which is service level agreements. This typically covers when you have an agreement around, say, for I'll take an example of certain software agreements where you actually have sold the software and then also have certain service obligations. You kind of cover certain obligations around the response time to a complaint, what are going to be the escalation matrix, what is going to be the uptime, downtime related obligations, what are the penalties if I breach the uptime obligation or the downtime obligation is breached? If I don't respond within the timelines prescribed or the TATs prescribed within the agreement, what happens? Those kind of things are typically covered under the service level agreement. The next agreement, which is very, very common, is employment agreement, which typically covers your terms of employment with your employer. The last but not the least, I've spoken about license agreement also when I spoke about the lease agreement. But this license agreement that we are talking about is any other uh, property, intangible assets like IP, trademarks, product technology, etc. When you are wanting to license or give certain limited rights to a third party to use that property, then that agreement is license agreement. Even for that matter, when you enter into, say, for example, advertising agreements with your celebrities and all, what they give you is the license to use their personality rights. So those IP related agreements, trademark related agreements, etc., where the rights are given to a third party to use it in a limited fashion, are termed as license agreements. Moving on from here, the transaction documents, why this is categorized separately is this set of documents is slightly different. It may not be something that you come across on a day-to-day basis. These are typically related to the fundraise related documentations, and therefore this is a separate category that we have created. Some of you may have heard it, some of you may not have. The types of those documents are SSA, share subscription agreement, where one party is investing its money into the company and subscribing to the shares of the company, and the rights around that whole transactions are governed by the SSA, which is share subscription agreement. Then you have SPA, which is share purchase agreement, when you actually go and buy shares from an existing shareholder and become a shareholder of the company. Then the exchange of rights and obligations between these two parties, that is existing shareholder and the incoming shareholder, are governed by the SPA, which is share purchase agreement. Then you have SHA, which is shareholders agreement. This defines the broader array of rights that the shareholders have within the company, and the understanding between the shareholders, etc., is captured in this document. It's called shareholders agreement. And the last one, uh, in transaction documents, again, employment agreement becomes important. But in this case, typically it is only related to the key managerial personnel and the founders of the company or promoters of the company. And that's why employment agreement also becomes an important part of the transaction documentation when you enter into some sort of a transaction or fundraise transaction or issuance of shares and related documentation. Moving on from there, uh, now let's understand certain critical clauses in the agreement which need to be viewed, reviewed, vetted very, very carefully. Uh, there are certain clauses which fall under restrictive covenants. Those restrictive covenants put certain level of restrictions on the party to not to do certain things during the tenure of the contract or sometimes even after the termination of the contract. And those clauses would be something like non-compete clause, non-solicitation. So you can't get into a similar or same business as me. That obligation is a restrictive covenant on you. It's non-compete, non-solicitation. You cannot, while you are in contract with me, you cannot poach people or approach my employees for hiring purposes, etc. Those kind of clauses and non-disparagement. Obviously, typically these kind of clauses kind of clauses are in transaction documents also. These kind of clauses you will find also in the marketing and promotional kind of endorsement related contracts also, where you ask celebrities not to engage in any kind of disparagement, etc. Then there are confidentiality related clauses, which keep the contents of the agreement as well as other defined information as confidential and then defines the obligations around it. So we've seen before that there is non-disclosure agreement, which is an exclusive contract only for the purposes of confidentiality. But a lot of commercial contracts, in fact, almost all of them will have a confidentiality clause in itself also, which will define the information that you want to keep confidential as confidential information, and then define the obligations of each of the parties around that information. That's your confidentiality clause. The next one is consideration. This is one of the most critical clauses because while it sounds very easy to define, that consideration is something that you give or make payment of uh, against whatever services or products that you are receiving from other party. In a lot of complex contracts, the consideration is paid very, very differently. Sometimes it is staggered, sometimes there are penalties attached, sometimes there are credits attached, sometimes there are multiple other things subject to which the payments become due, etc., etc. So the consideration clause is a very critical clause, and the drafting of it needs to be very, very careful. Then there are reps and warranties. There are certain things that you represent to other party as certain things being done. There are certain things that you tell the party that you'll make sure during the tenure of the contract that you'll follow. Those become your reps and warranties. So the capacity warranty, that I'm competent enough to enter into the contract. There are certain specific warranties, general business related warranties, product warranties, etc. Typically, these things will be attached, or the breaches of these things will be attached to your indemnity clauses. So when you breach these kind of clauses, you have to compensate the other party for the damage caused. Yeah. So reps and warranties is very important. You need to be very careful as to what all are you representing in the contract, as well as what all are you warranting. And therefore, it becomes very, very critical for you to keep an eye on the warranties that you've given in the contract so that you make sure that during the tenure of the contract, you follow it in letter and spirit. Then comes the dispute resolution clause. This becomes very important because a contract, after it is executed, goes into a drawer and only gets out when there is a dispute between the parties. Otherwise, nobody cares about it. So the dispute resolution clause is one of the most important clauses because there you actually get to decide as to what path do you want to take in case there is a dispute. Sometimes you may simply want to have courts deciding on any dispute between the parties. Sometimes you may want to have a detailed process of conciliation, mediation, then arbitration, etc., etc. In which case, if you have chosen arbitration as your dispute resolution mechanism, then it always makes sense to have the entire process of arbitration also defined and agreed in the contract because it solves for a lot of problems at a later stage. So things like your preferred seat of arbitration, venue of arbitration, the language in which the arbitration proceeding will be conducted, how many arbitrators do you want? Is it going to be just one, or both parties will appoint one and then those two will appoint an umpire? Or do you want to follow certain specific rules or certain predefined rules of arbitration, etc., etc.? Everything should be ideally written down and agreed between the parties at the time of execution of the agreement itself. And then IP terms. In a lot of contracts, there are certain licenses being given. There are certain developments that are happening during the term of the contract. So, what is it that you want to own on your own? What is it that can be a joint IP? Uh, is it going to be a work for hire kind of a contract where you're just asking them to provide their services and they're acting on your instructions, and therefore whatever is the outcome in terms of IP belongs to you? Need to be very clear on those aspects and then define your IP terms in the contract. Again, this is a suggestive list of clauses, but these are very, very critical clauses that one needs to keep an eye on. Now let's understand what is boilerplate clauses, because it's a very commonly used term, and sometimes you don't understand exactly what boilerplate means. So definition, if we look at the definition of the term boilerplate, it is I mean, look at if we look at the literal meaning, it defined as or derived from a metal plates on which ready to print copy was supplied to newspapers, which could be modified before printing. But essentially, it means a typical boilerplate clause is something which you will find in almost all the clauses, all the contracts, and then only changes based on the basic intent or nature of the contract, or small changes are made in those contracts. Uh, let's have a look at these clauses to understand it better. So say for example, a survival clause, then in every contract you'll find a clause which defines or uh, specifies the clauses which will survive even the termination of a contract. And it kind of becomes a clause which is used in every single contract. So your clauses like confidentiality, non-compete, breach of reps and warranties, etc., is something that you will say that it will survive even the termination of the contract. What does it mean? It means that if there is a breach found out after the termination has happened, and if there is damage for which a suit can be brought on, these clauses, these obligations will still survive. And therefore, even if the contract is no more valid or terminated already, these clauses still remain to be valid. Similarly, you will find jurisdiction as a standard clause in every single contract, because you want to define, typically in modern days where uh, both the parties are sitting in very different geographies, it always helps to have uh, identified jurisdiction very, very clearly. It also helps from sometimes from the point of view of where and how the stamp duty obligation from the point of view of stamping the contract will arise. Uh, then no partnership, assignment, and these kind of clauses are very specific. Uh, I'm not saying that the language of these clauses will always be the same, but these clauses will always be there in the contract. So uh, to make sure that the parties don't become partners or agents of each other, you bring in these kind of clauses. You clearly spell out that the parties are acting on principal to principal basis, and therefore each one to its own kind of relationship, where whatever you do, you are responsible for it. You are not my agent and therefore not representing me outside the market, etc., etc., will be covered by no partnership. Then there's assignment, where you actually restrict the parties or allow the parties in a limited way to assign their rights and obligations to a third party. That comes under the assignment clause. Force majeure, after COVID, this clause has become the most talked about clause. Typically, it deals with the events which are not within the control of any of the parties, and because of which the performance of any of the obligations become impossible for the parties. Force majeure actually deals with those kind of situations. And then you define what happens. Say, for example, if I define force majeure event as earthquake, fire, blah, 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 and then say that in case of in a lease agreement, if I define force majeure event as earthquake, fire, or whatever, and then say that in case I'm incapacitated from utilizing the premises because of a force majeure event, the rights attached to it is either I, after 30 days of such event persisting, either I terminate, or I can also have a clause where I come back to the table and negotiate the rentals, etc. So force majeure typically deals with those kind of situations which are beyond control for either of the parties. Then comes amendment. How do you want to amend the document? How do you want to make modifications to the document at a future date is captured in this clause. Then publicity and use of logos, etc. Whenever two commercial parties are entering into the contract, they both have their own trademarks, they both have their own logos, etc. And then there may be some limited usage. Say, for example, to release a press release or a joint marketing material in the market, both of them can use each other's marks, but not for any other purposes. Something like that in the publicity and use of logos, you would end up defining. The further acts, uh, it kind of defines all or make sure that assistance assistance by each one is given in making sure that the transactions, operations, etc. in the agreement are uh, taken forward. So, what are the steps that you need to take to assist each other to complete the transactions or agreements will be covered in these kind of clauses. The expenses, there are considerations defined, there are obligations defined, there are rights defined, but then there may be certain expenses which are outside of those consideration, and it's always better to capture who will bear what. Then interpretation, as to if there are certain rules of interpretation. Say, for example, if there are certain specific terms which are defined in certain specific formats in the contract, you will need that interpretation clause telling that the first clause that you refer to is the interpretation clause, then the definition clause, and then if there is still some confusion, then maybe the general interpretation, etc., etc., will be captured in the interpretation clause. Moving forward to few more clauses, counterparts. You end up defining the number of counterparts and the confirmation that all counterparts are in original. Uh, Counterparts are typically you may either execute the contract in two original copies, or you may also want to call the first copy as original and all facsimiles of it signed in original as original, or you may also want to call out that original signed agreement plus the color PDF of that document will be considered as original, etc. It helps to uh, make sure that when the other party produces it as evidence, it still has certain things to rely on. Otherwise, the Xeroxes are not so easily admissible in evidence. It takes care of those kind of issues. The waiver, if you are, if any of the parties is actually waiving or not waiving any of the rights, that is captured in the waiver agreement. Entire agreement. What all do you want to call out as the agreement is covered here. So there may be certain previous exchanges that have happened. There may have been certain LOIs exchanged. There may have been certain written discussions that have happened between the parties. Either you say that everything else is invalidated and only this agreement prevails from this time on, or you say that except for clause so and so in LOI, everything else in this agreement will prevail. Something like that. So what is meant by entire agreement is covered in this clause. Then there are clauses relating to set-offs or counterclaims. Typically, these clauses deal with when you are settling the compensations or the considerations in the agreement. Can you set off certain things uh, against the consideration, or can you set off certain things against the claims made by the other parties, etc., is covered in this clause. Then severability. Uh, if so typically if one part of the agreement becomes invalid or unenforceable for some reason, say for example change in law, then this clause takes care of the other clauses. So typically in this clause you will call out that events including change in law, then the remaining portion of the agreement will remain valid and enforceable. Those kind of things will be covered in this clause. Okay, now that kind of brings us to the do's and don'ts of contracting. It's a bare shell list that I've given, but these are very, very important things to keep in mind when you are entering into a contract. Let's go through the do's first. And it's a very basic list. Ensure that all prerequisites of a contract are met. Now, what is prerequisite of the contracts? All of that which is defined in the Contracts Act. Plus, if there are certain things to be done by either of the parties before executing the contract, make sure that all of that is available. There has to be two consenting parties, offer and acceptance, consideration, free consent, everything has to be uh, met with, and then only your contract will be valid. Therefore, make sure that all that is present. Follow the structure of the contract as far as possible. When I say structure of the contract, uh, it typically starts with your recitals, then the definitions, reps and warranties, covenants, obligations, and then follow other clauses, including those that we spoke about in the uh, boilerplate clauses. So just make sure that you follow all those in letter and spirit, because a proper flow of the agreement, uh, if it is ensured, then it's easier to interpret the contract than a contract which is not in a specified flow, or which is jumbled, which has clauses jumbled up. Uh, Obviously, the contract has to follow the applicable laws connected to the subject matter. Uh, it goes without saying. The defined terms which are repeated throughout the draft. It's always advisable that if there are certain terms which are repeatedly used in the contract and has certain meaning in your mind, define them very specifically in the definition clause. Then specific commercials can be moved to a schedule or PO to increase the readability. It's a very good approach that one can follow if there are going to be the orders placed frequently, and the sizes of those orders are going to be different at each time. Then it's always better to capture the essence of contract in one part, and then have your commercials captured in a schedule or a purchase order. And those purchase order can be every single time when there is a new purchase order, you can keep on attaching it to the contract as part of the contract. Then defined terms should be used in capitalized manner. It's a hygiene issue. Whenever there is a defined term in the contract, and whenever that term is used somewhere else in the contract language, use capitalized words to capture that term. It gives clear understanding that this is the defined term that is being used here. It's a normal rule of contract. Then check if section references and cross references are accurate or no. Typically, in every contract, you will need to have references and cross references of other clauses also, and it is very, very critical that those cross references are accurate. Say, for example, if you are talking about certain payment obligations to be met before the contract is terminated, then the reference to those payment obligation related clauses in the termination clauses has to be absolutely accurate. Then stamp the document appropriately and stamp the counterparts too. Stamp duty is different in every state, so one has to be aware of what is the applicable stamp duty on the contract, and make sure that you pay that stamp duty on all the counterparts also. Also make sure that the stamp duty that you calculate is also in accordance with the act. And why I'm saying it is very important is because the Stamps Act typically uh, says that if the stamp duty is not paid properly on the document, it may not be used as evidence. So the sole purpose for which you are executing a written document is to be able to refer it in case of a dispute. And if you have not stamped it, you won't be able to refer it only as evidence. So it might as well make sure that the stamp duties are paid accurately. Then decide the number of counterparts prior to execution date. If you are physically executing the document, it makes sense to decide the counterparts beforehand and then execute the documents accordingly. Some of the don'ts, draft simply, concise while covering all requirements. Um, Ambiguity should always be avoided. Uh, there's no point in time. There should not be any ambiguity in the clauses. Don't use complicated language. Define the timelines clearly. Define the responsible persons very, very clearly. Define how the notices are to be served, etc., etc., so that everything is crystal clear. Defining terms which are contrary to its normal usage. While I said that the definition clause should cover the definition of the terms that are used, and definition should be what you think they should mean, but it doesn't mean that you use a term in a sense which is very different or contrary to the normal usage, because it will just confuse the other parties or even the interpreters. Redundancy, cross-referencing has to be used in the contracts, because that will help you reduce the redundancy. Say, for example, just in the same example that I gave when I spoke about two clauses, one is termination, the other one was payment obligations. And if you don't use cross-referencing, then you'll probably end up mentioning the payment obligations again in termination clause, which will increase the redundancy and create unnecessary repetition. So use cross-referencing to reduce redundancy. Execute the documents in a combination of digital and physical execution. This uh, is best avoided, because then it just creates confusion as to which one to be relied on in case of a dispute. And just in case there are some differences between these two documents, it will be a nightmare in case of a dispute. And therefore, it's always advisable to decide beforehand as to whether you want to go physical or you want to go digital. Uh, Defining the same term in multiple ways, obviously you want to avoid that and leave the document with multiple fonts and structures, etc. Because then it's just impossible to read and understand. So these are the do's and don'ts, and that brings us to the closure of the subject today. Just to take you through what we are, in terms of what is LawKNIT and a snapshot. We are a law firm which has about three offices: Bangalore, Indore, and Mumbai. Uh, we have just started Mumbai office in December, and we have tie-ups across two major cities, Hyderabad and Delhi, and can represent matters across India also. Uh, we apply solution-oriented approach because we are trained over uh, a lot of us work with a lot of corporates, and therefore the approach that we adopt is the problem-solving approach rather than just telling what is right, what is wrong, and without advising on how to get around with certain things. So that's one of the key factors. Uh, we are a tech platform, and we are trying to change the way in which we interact with our clients, and therefore the platform kind of serves as an interface between us and our clients, and we interact with our clients via the tech platform. So a lot of clients that we have are startups or mid-size, small-size companies which may not have the legal teams or full-fledged legal teams, and therefore it helps us to interact with non-legal people also via the tech platform. Our practice areas, we are a full service law firm, and primarily we deal in PE, VC, M&A, general corporate technology, media practices. Along with that, we also do disputes, IPR, and India entry, employment, etc. related consulting. What all do we do, uh, and what all do we stand for? We have we have enough experience in startup matters, including fundraise based out of India, Indian Silicon City of Bangalore. So
Amol,
Arnab
I
and
think we can open the house for Q&A.
sure.
Yeah. So if anyone has any question, because we have another 5 minutes. So, Amol, can you shift the slide to the next one? No, after this. Yeah, this one. So, Amol, before anyone asks any question to it, let me ask you one question. This is one question which we received while by someone who was registering for the session. What they asked is that at times they get a lot of documents, agreements stating that it's a MOU, okay,
Okay.
memorandum of understanding,
Okay.
and they sign it just like a normal agreement. So the question was that whether is there any difference in enforceability or understanding when agreement is named as a MOU and an agreement is named as an agreement. Okay, what is the legal basis of that?
Got it. So see, typically, the Contract Act doesn't define anything as memorandum of understanding per se. So the difference lies in the way the intent of the parties is captured in both the documents. Just because I have named a document as memorandum of understanding and not as a contract or an agreement doesn't mean that it is not it is not an enforceable document. But what we'll have to see is how the intent of the parties is captured in the document. What we typically do in memorandum of understandings is just capture the understanding and not the entire way in which things will be executed. And therefore, uh, if you have a document which is named as MOU, but in detail captures rights, obligations, rights against breaches, etc., etc., then that nomenclature is not going to help you. So my advice is to have a careful look at the language and then decide whether it's actually a MOU or an agreement in itself.
One another question which was there on restrictive clauses, this non-compete, non-solicit, how it works in employment agreement.
So non-compete, non-solicit, while they are used uh, in one breath typically, and they you'll find those clauses together in almost all the employment related contracts. The legality of those is slightly different. So non-compete, how it works is when you want your employee not to pursue any employment with something that you consider as competition. Now, pursuing any trade or commerce of choice is a fundamental right in the Constitution of India, and therefore, even the Contract Act Section 27 kind of bars any contract which is in restraint of trade and commerce. And therefore, uh, if I look at non-compete very, very technically, then it's an unenforceable clause. Having said that, there are case laws which define as to what makes this clause reasonable. So if you define it in such a way that it has a reasonability attached to it in terms of three things: territory, timelines, and the spread of the entire thing. So say for example, I want you not to be employed with a competition within the territory of the state of Maharashtra for a period of 6 months. That probably is a reasonable clause. It still will be subject to dispute, but at least there is a possibility that you may be able to enforce it. If I say that you will never be employed with my competition, then I will never be able to enforce it. That's about non-compete. Non-solicitation, however, is something very different. There you are not asking him to or putting a restriction on somebody to follow a trade and commerce, but just putting a restriction on him approaching your employees or approaching your employees with an intent to poach. That still is enforceable contract against the party who is poaching. So these two clauses you will typically find in employment clauses. One is enforceable, the other one non-compete. Courts typically take the stance in favor of the employees unless you draft it in such a way that they have reasonabilities attached to it.
One another question is that which most of the time our clients keep asking in case of a dispute resolution. Okay. Now, at times, dispute resolution, the clause says that it can be subject to any of the court of that particular jurisdiction. Like, for example, any of the court of Bangalore.
Yes.
Second way of dispute handling is by going through an arbitration process.
Yes. Yes.
Under arbitration process also there is like sole arbitrator and appointment of multiple arbitrator, including three arbitrators. Okay. Now, given the cost and time and the kind of contracts which our clients enter during the
Yeah.
time, right? At times it's a specific small contract. At times it's very high stake contract. How do you frame that? What our client should do with regard to this dispute resolution? When to choose for court and when to choose for arbitration, and when to go for a three bench arbitrator.
Yeah. So, see, when the Arbitration Act was released, the intent of it was twofold. A, to reduce the burden on the judiciary, and two, have a faster cheaper, economical resolution of disputes for, especially for commercial kind of disputes. What has, however, happened is that over a period of time, the arbitrations have become expensive and time consuming both. For the simple reason that there are quite a few provisions where parties end up approaching the courts again and again to get certain orders while the arbitration is still on. And therefore, it has become very lengthy and cost ineffective kind of a mechanism. Therefore, in my opinion, in smaller contracts, while the definition of smaller and larger contracts can still be different for different parties, but just to give you a sense, any arbitration, single arbitrator in uh, cities like Mumbai, where you have a arbitration seat at Mumbai, will cost you about 75,000 rupees per hearing for the arbitrator's fees only. And this is not including lawyers' fees at all. And therefore, it's very expensive. So for smaller contracts, I would still advise that go for courts rather than arbitration. For larger contracts where you actually have a lot of technicalities involved and you know that you will probably end up appointing somebody who understands these technicalities, etc., you may want to have the arbitration clause. Uh, Also, if it's a very large commercial contract, say oil and gas typically uses arbitration, and it also has the arbitration panel rather than single arbitrator, where one party appoints one arbitrator, the other one appoints the other, and those two arbitrators then appoint an umpire. Oil and gas kind of disputes, which run in multi-million dollars worth of deals or disputes, there you may probably want to have a panel of arbitrators deciding on the case, because then the chosen arbitrators also belong to a, or rather come from a background which understands uh, oil and gas kind of disputes. You need a very peculiar sort of understanding of the contracts. There probably you should go for panel, otherwise you shouldn't.
Yeah, in fact, in the context of the current people who are joining, something like their investment agreements,
Yeah.
a panel of arbitrator is something which is recommended from investor side and your side and all those things. All your commercial agreements, you can judge between a sole arbitrator to a jurisdiction to a court, civil court of that jurisdiction. Uh, uh, Attendees, please feel free to write. You can unmute yourself and speak also if there is any other query. I have last question with you, Amol, is with regard to termination. If something is going wrong in the agreement, okay, and if party wants to terminate. So suppose if someone has not paid my bills and I'm still working for it, okay, now I don't want to work and I want to recover my money. Should I terminate my contract? Should I not terminate my contract? Continue with the contract without delivering? How it works with regard to termination and dispute?
So termination, while obviously every contract will be governed by how the language in the contract is captured, uh, and therefore it may not have a standard answer for all of the commercial arrangements. But typically, something that you have already delivered for which the payments have already become due, if you terminate those contracts uh, on a going forward basis, your dues can still be recovered via a dispute, and therefore the termination shouldn't cause any problem in your already accrued dues recoveries. Having said that, if if your contract has, say, three staged sort of dispute resolution mechanism of mutual conciliation, then mediation, and then arbitration, it always helps to continue the contract and then get into the processes of mediation and conciliation, because that keeps the relationship going, and therefore the trust is still there, and therefore there's a possibility that you may end up resolving your disputes at the mediation stage itself rather than going into the litigation stage. But yeah, whatever you have delivered, for which the dues have already accrued, even if the contract is terminated as of today, whatever has happened in the past is enforceable.
Got it. Got it. Great. I think I have covered all the questions which were earlier asked in the registration form. Anyone has any question, please feel free to ask. And anyway, we will be meeting on 20th. That will cover a lot of case studies, technically giving you some practical scenarios which we have seen, and including some of the questions which we discussed with Amol right now. And at the last of that session, we will also give you templates or show you templates where to take various verified templates from LawKNIT's site. And of course, it will be a session, and then we'll also cover certain other provisions. So it's day after tomorrow, you will get a registration form. Uh, Thank you for your patience hearing. I think we have almost exceeded the time by 4 or 5 minutes. Amol, last words from you, and we can close that.
So, just last one thing that I wanted to talk about is on the platform. Uh, it's a so LawKNIT platform. If you guys haven't seen it before, it actually gives you an access to a platform which provides various templates, knowledge products, etc., etc. So when you engage with us, it's not only the lawyer's time that you get, you also get access to the platform which has certain knowledge based products, and we keep on updating that knowledge base for you to use. Also, when we work on your contracts, etc., uh, we also keep on templatizing it for you. So for every single contract that you come to us, you may not need to come to us for uh, drafting from scratch in future, because we've kind of converted that and stored on the platform for you to access in future. So those are the kind of features that we use on the platform, and we keep on doing these training sessions along with providing the uh, reading material on the platform in the form of our knowledge products, and therefore it's a very very useful platform when it comes to clients who don't have a very large sort of legal teams, etc., or have a smaller legal team. So just make use of the platform to the best of your ability, and you'll really find a lot of things which are useful for you.